Hi there. Today is December 29th, 2022, and we're being joined today by Mike Bascom here with our Ask an Expert series. We're going to be meeting with him. He is an estate planning attorney, and he has been practicing for the last 33 years in the fields of estate planning and elder law specifically. Today, we're going to be talking about changes in the law, including death tax changes, gift tax rules. Mike, we're glad to have you with us today.
Thanks for having me. I'm excited to talk about these new rules.
Excellent. So let's just jump right into it. What are the new rule changes for 2023?
Well, the two that draw the most attention are the increase of the overall exemption and also the exception to the exemption. The new rule for 2023 for an estate tax, the exemption amount is $12,920,000. So as long as your estate is that amount or less, then there's not going to be an estate tax. You're also allowed to have transfers throughout the course of a year, and that rule now allows transfers of up to $17,000 per recipient for there not to be a gift tax on those transfers. And that's cumulative throughout the year, and it's per recipient, not per giver.
Okay, great. So how do those changes affect couples, for example?
Well, couples are allowed to do double those. So for a couple, they can have a combined estate of $25,840,000 without there having to be an estate tax or an inheritance tax for the kids when they pass away. And likewise, if one of the parents wants to give a gift to a child and it happens to be more than $17,000, then we can do what's called gift splitting, and we can have it pretend as though the gift came from both parents. So both parents could give up to $17,000. On the flip side, if it's a single person giving to a child that happens to be married, you could give $17,000 to the child, and you can also gift up to $17,000 to the spouse. So there's multiple ways that those rules come into play.
Okay, excellent. And how does that change if, for example, the spouse is a non-resident of the United States?
Well, one of the rules that we have allows unlimited transfers to a U.S. citizen spouse. If your spouse is not a U.S. citizen, then the annual gifting amount is not unlimited, but instead it's capped at $175,000 per year.
Okay. Changing gears just a little bit, I had heard a lot of conversation about the step up in basis rules. Would you mind explaining what step up in basis is and whether or not there's been any change and what that change has been?
So great question. The step up in basis rules have not changed. A basis is what you pay for an item. So for instance, if you paid $10 for an item and it goes up in value to 30, then the difference between the 30 and the 20 is a gain. And if you sell the item, you'd have to pay tax on that amount. Well, can you get out of the rule by giving the asset to somebody else? No, because they would get your basis. So you paid 10 for it, they're treated as though they paid 10 for it. The time that it's different, though, is if the reason they received it was because you died. If that's the case, then we're allowed to take basis and step it up to the date of death value. So in my example, if it's valued at 30, we're able to increase the value to 30. So 30 minus 30 is 0, so it effectively wipes out the capital gain on a highly appreciated asset by inheriting it through the use of the step up in basis rules.
Oh, wow. So that could be really substantial for an estate.
It can. Now, realize that the step up in basis rules do not work for IRAs, but they're terrific for hard assets like real estate, stocks, and private companies, things like that.
Okay, so the rule there hasn't changed. Are there any other rules that we should know about that haven't changed from 2022 to 2023?
Sure, there's a couple that are out there. One important one is the marginal tax rate has stayed at 40%. So if you exceed the exemption amount, it's still a 40% marginal tax. So any dollar that you have that exceeds the amount, 40 cents would be shaved off in tax. That's one of the rules that has not changed. Another rule that's not changed is you're also allowed to leave or give unlimited amounts for a particular person for their educational expense, as long as you pay the money directly to the educational institution. Don't give the money to a grandchild and have them pay it. Give the money directly to the school, for instance. That same rule applies for health expenses. So you can pay medical expenses directly to the recipient's medical care provider, the hospital, the doctor, et cetera, and that does not count as part of the 17,000 annual exclusion. And of course, gifts to charity, those are unlimited. You can give as much as you want. There's not a gift tax or a transfer tax on any gifts that you decide that you're going to give to charities.
Okay. 40% as a marginal tax, that seems that's a large number. What does that 40% apply to? Which number are we talking about here?
So any transfers that exceed the annual exemption amount. So in this situation, $12,920,000. If you have more than that when you pass away, the 40% marginal tax is going to be applied to it. Now, Georgia's pretty nice. We have not adopted a separate state estate tax. We just mimic the federal rules. There are 17 other states that have enacted their own estate tax exemption, and frequently it's substantially less than the federal amount. But Georgia does not have a separate state estate tax.
Okay. And that 12.9, is that going to be the new limit forever? That's what we're looking at?
Well, each year it's going to increase a little bit. In the year 2026 or at the end of 2025, the rule is set to sunset, which means it's going to go back to what it was several years ago. And we're expecting that that amount's going to be somewhere in the $6.5 to $7 million range. Of course, the president and Congress could change the rules, but right now, if they don't change the rules, then they will revert back to the old rules. And like I said, we're expecting it to be somewhere in the $6.5 million to maybe $7 million mark.
Okay. And then I think the last question I have for you, I've heard the term clawback. Are there any changes or what's going on with the clawback rules?
Sure. So a clawback refers to someone making a transfer of assets that exceeds the reset amount. So let me give you a specific example. Let's say a person has $9 million and they decide to do some transferring of that. That's clearly under the exception amount that is allowed of $12,920,000. But if the rules reset at the start of 2026 and the new rule only allows 6 million, if you've already transferred 9 million, then that extra 3 million, should the IRS be able to tax that transfer? And that would be a clawback if they were to tax that particular transaction. The IRS has made it clear that they are not going to do a clawback as long as you adhere to what the current rules are. So if the rule resets and you've made transfers that are higher than what the reset amount is, you're safe. You're not going to be subject to clawback rules.
So it sounds like it would be better to die in 2025 than potentially in 2026, huh?
Well, unless some planning is put in place. Of course, there's lots of advanced strategies that can be put in place to help minimize or reduce the estate taxes, but it requires a little bit of time and effort. As we get closer to the end of 2025, it's more expedient to get those strategies put into place. Of course, the more time we have before it's actually needed, the better. But that's balanced with not putting complicated things in place if they may not be needed.
Excellent. Well, thank you, Mike, very much for sharing your wisdom with us today. If someone would like to get more information or get in contact with you, how would they go about doing that?
Well, the simplest way is just contact our firm. Our phone number is 770-889-3911, and we'll be happy to talk more about advanced strategies if you're interested in learning more about the estate tax rules and how they would impact you in 2023.
Great. Thanks so much, Mike.
Glad I could be part of the show.